In the previous lesson, we discussed the question of existing consideration, noting that if you are already performing some action, or there is already some kind of detriment or forbearance that you are engaged with, this cannot represent a new form of consideration for a new agreement. There has to be some additional thing that takes place. This is the general rule for existing consideration. However, there is also exceptions to this general rule, and we'll talk about these exceptions in this lesson when we talk about this idea of exceeding consideration. So we noted that, for example, the existing duty to perform some action can never amount to a new consideration for a new promise. This is the general rule. We also noted that a statutory duty to perform some action, such as a subpoena, cannot also represent new consideration for a new promise. This is true and is the applied general rule. But exceptions to this rule do exist. The most important of these exceptions is this idea whereby an individual is actually exceeding their ordinary amount of consideration for their original promise. This exceeding of consideration can represent a new form of consideration for a new contract. And we'll talk about how this can actually amount to new consideration in this lesson. So that was the general rule. If you have already contracted to do something, and you have therefore got consideration on the part of you, or at least you have agreed on the consideration, and then you perform that duty. Okay, the existence of that duty does not mean that you can't. Does mean that you essentially cannot. You cannot require that a new agreement be valid on the basis of the consideration that you're already doing. It cannot represent new consideration. However, fundamentally, if there exists some statutory or contractual duty that must be performed, this normally cannot amount to new consideration. That's the general rule. However, if one goes beyond and performs more than this statutory or contractual duty obliges them to do so, this additional performance can amount to a new form of consideration. And then there are two cases that illustrate this point very, very nicely. Exceeding of contractual duty of statutory duties on the one hand, and then exceeding on contractual duties on the other hand. So the first here talks about the exceeding of a statutory duty, the 1925 case of Glassbrook Brothers Limited versus Glamorgan County Council. The facts of this case take place during a miners' strike. The Glamorgan County Council had agreed with the defendants that they would provide an additional 70 policemen at the colliery of the defendant if they would return this favour with some kind of payment. When the defendants refused to pay, they sued for the breach of contract. The issue here, however, was that there was a statutory duty on the part of the county council to provide the defendants with policemen at the issuance of strike action. So where there is some kind of strike, such as a miners' strike, the county council has a duty to provide police, and this is a statutory duty on the part of the public authority. So the argument here was that the adding of policemen or the issuance of policemen does not represent consideration, given the fact that, according to the general rule, this is the statutory duty that the council had to do. So this, in return for some payment, was not contractually obliged. Theoretically, however, what the county council argued was that while there is a statutory duty to provide police officers during some kind of strike action, such as a miners' strike, they had actually exceeded their statutory duty by saying that they were going to provide an additional 70 police officers. And so by providing so many, this had gone beyond what would reasonably be considered to be the statutory duty of the public authority. This additional providing of, or the additional provision of more police officers, therefore represented a new consideration for a new agreement, and so therefore the contract was valid. Now, it was a close decision in the House of Lords. It was a 3-2 decision, but they did hold that going beyond the statutory duty does actually confer sufficient consideration to establish a new contract. So the giving or the providing of police officers in and of itself is a statutory duty, and so would not have represented consideration for this contract. But the providing of so many police officers exceeding their statutory duty would have provided the necessary consideration to establish a contract. So essentially, it was held that the defendant requested services which went beyond the statutory duty of the council and the police. And it establishes the view that the additional detriment in providing more than the statute obliges creates this new consideration. So this is an example of exceeding a statutory duty which gives rise to new consideration. What about the exceeding of contractual duties which gives rise to new consideration? Well, this is a case that I talked about at the end of the last lesson, the case of Hartley and Ponsonby from 1857. This was another case which involved sailors trying to get more out of their captain midway through a voyage. So the previous case of Stilk and Myrick was a case where they had gone to the Baltics and come back again to London, and 2 of the 11 crew deserted. The conditions were harsh, and the captain refused to pay them this additional amount of money in return for their essentially finishing the voyage. And it was argued in that case that they had already contracted to go on this voyage, and so they cannot have gone and used the same consideration to create a new contractual agreement. This case is a little bit different. The main difference here is that the remaining sailors were promised additional pay if they took up the work of a number of deserted members. So a number of people had deserted on this voyage as well. However, where the case of Stilk and Myrick, there were only 2 of 11 crew deserting. In this case, 17 had deserted. So quite a significant number more people had deserted, which changed quite significantly the nature of the job for the remaining sailors. It was held that the promise made by the captain was enforceable, owing to the fact that, given such a reduction in the crew, and given such a change in the nature of the work that had been performed, the returning home was far more dangerous and required far more additional work from the remaining crew, given the fact that 17 had deserted, quite a significant number. And so this meant that they had gone beyond their contractual obligations by not only performing what the contract told them to do, but performing more than they were obliged to do under that contract, owing to the fact that there were 16 desertions. And so the result was, as a result of this, that this represented new consideration and therefore made the promise enforceable on the part of the captain.